All right, everybody. Thank you so much for joining. It is Friday, December 12th. It is noon, depending on where you are in the world. And we have made it through another week. Congratulations. Give yourself a pat on the back. Today, we're going to be talking about a historic AB 1071, the latest RJA bill, which was signed into law this year, October 13th, so just about 2 months ago. Today, we're going to discuss what the law does and why it matters most to our communities. So, just some quick housekeeping points. This webinar is being recorded. So if you have to step away, if you mishear something, you will be given access to the recording afterwards. Since it's webinar style, we cannot actually see any beautiful faces of yours. So please use the chat. We want to know your questions, your thoughts, your concerns, reactions, anything that you want to share with us as you're hearing speakers talk about the RJA. We really want to know what you're thinking, and the chat is going to be the best way for us to engage with you all. So please use it, utilize it, talk to us. For today, we're going to have a quick RJA overview. We're going to have some legislative updates where we dive a little bit deeper about AB 1071 and we talk about SB 734. We're also going to have some really cool updates from community organizers. Towards the closing, we're going to share some resource guides, some calls to action. We'll have space for questions and answers as well. But before we do any of that, we're going to hear from a very special guest, someone who's been our champion of the Racial Justice Act since the beginning, representing the 25th Assembly District, Assemblymember Ash Kalra.
Especially with all of you incredible advocates, our Baker Center folks that have been there since day one with the Racial Justice Act. It definitely has been quite an incredible journey, but that journey continues, and AB 1071 is part of that process. And I know, just like every other part of the Racial Justice Act, 1071 had its ups and downs before getting to the governor's desk and ultimately signed. But I just want to express my gratitude to all of you for being part of the journey, being part of the community that is ensuring that we're not going to stop fighting for racial justice, fighting for equity, and fighting to root out systemic racism in our criminal justice system. And so I just want to thank everyone that's there, everyone that's going to be speaking to help talk more about 1071 and how we can look forward to having it implemented. And as always, I look forward to continued work. I'm sure there's going to be more RJ work in my future before I'm done with the legislature. And I know that all of us will be working together to make sure we see that through. So again, thank you everyone so much. Thank you to everyone that made 1071 a reality, made the Racial Justice Act a reality, and here's to a productive webinar today. Thank you.
Right on. Thank you so much, Assemblymember. All right. I think next we're going to hear from Morgan. Morgan's going to talk to us about the RJA and give us an overview. Morgan, how you doing over there?
I'm doing great, Fatima. Thank you so much. And I know it was great for all of us to hear from Assemblymember Kalra, an incredible champion of racial justice and the Racial Justice Act for the last 6 years. And I want to just take a moment to remind folks why we're here, what the Racial Justice Act is, and remind us of just the basics before we think about how we're moving forward and how AB 1071 is moving us forward. So just jumping into a little bit of the history, the California Racial Justice Act, AB 2542, was first passed in 2020, and that law very clearly stated that the Racial Justice Act would prohibit the state from seeking or obtaining a criminal conviction or imposing a sentence based upon an individual's race, ethnicity, or national origin. And I think it's so incredibly important to just point out that all three of those areas are covered, right? Especially at this time and this juncture that we're at in our country and in the world, where California set out to ensure that we have a law that protects all individuals, regardless of their ethnicity, their nationality, their perceived race. And in 2022, the incredible co-sponsor group and Assemblymember Ash Kalra went back for AB 256, which made California's Racial Justice Act retroactive, meaning that individuals who had already been convicted and who are currently serving terms in California state prisons have the opportunity to challenge their convictions and sentences and to seek relief because of the racial bias and discrimination that they may have faced in the criminal legal proceedings. And there's one other really important thing that I want to reiterate about the Racial Justice Act, aside from the basics of it and how incredible this law is and how important it is to protect our community members who we know are most impacted by mass incarceration and over-policing. But I want to make it really clear that the Racial Justice Act currently only applies to criminal legal proceedings. I know that we often have folks asking about whether this law might apply in other areas or in civil proceedings. And there are other protections that exist in those areas. But for right now, the California Racial Justice Act only applies in criminal legal proceedings. So in those areas, folks can file their Racial Justice Act claims in order to try to seek relief for the bias and discrimination that they may have faced. And just to talk through really quickly some of the areas that the Racial Justice Act covers. So there are kind of two types of claims that you can think of. One of those bigger buckets has to do with an individual's statements, conduct, their actions. And another one has to do with statistical disparities, database information. So in terms of statements in conduct, this can cover both in-court and out-of-court expressions of bias. And those can be from any actors in a criminal case, including law enforcement, district attorneys, defense attorneys, jurors, and even the presiding judge in a case. And these are what are referred to as A1 and A2 claims under the Racial Justice Act. So these could cover evidence of explicit race-based bias against the defendant, really explicit examples of racial profiling or the use of racial slurs. It can also cover the use of racially discriminatory language that isn't explicit, that is implicit bias, that doesn't have to be purposeful. This includes racially charged or coded statements that may be said at trial. Some examples could be comparing the defendant to an animal, the use of language that we know is really racially charged and coded, like super predator, or the use of rap lyrics even to try to show someone's criminality. The other bucket, when it comes to statistical disparities, covers two different areas, and those would be charging and sentencing disparities, what are referred to as A3 and A4 claims under the Racial Justice Act. So for charging disparities, that would be being charged for a more serious crime than defendants of another race who are engaged in similar behavior, and where that person's county of conviction more often seeks higher charges on people of their race. For sentencing disparities, the language is kind of similar, but that's where a judge imposes a longer sentence compared to others with similar conduct, and where the county more often imposes longer sentences to others with that individual's race, ethnicity, or country of origin. And now that we understand a little bit about what these types of claims are, the next step is figuring out how to actually bring a claim. And the disclaimer that we always like to give folks is to really take your time with it. There's no time limit on the Racial Justice Act. It's mostly about making sure that you're as prepared as possible, that your loved ones are as prepared as possible to try to bring these claims before actually doing so. So, my best piece of advice would be to start by doing your research, by looking at all of the materials and resources that are in existence, and to try to reach out to your loved ones, to your loved one's county of conviction and the public defender's office there, and or a participatory defense hub in that general area to try to help steer you in the right direction and make sure that you're as knowledgeable as possible about the landscape in that particular county before trying to file an RJA claim. But to just understand the basics of it, how to bring an RJA claim. At trial, it would be alerting your attorney to any type of behavior and having your attorney alert the judge with the motion in court. If the judge approves that motion, then they would order a hearing on the violation. And if the hearing proves that a violation more likely than not happened, the judge would apply a remedy. For someone who has already been convicted and is currently serving time in a California state prison, again, reminding folks to do their research and reach out to those resources that do exist before filing a claim, just to make sure that they're as prepared as possible. But then from there, the individual would alert the judge for their county of conviction with a habeas petition. If the judge approves that claim, they would appoint an attorney and order a hearing on the violation. And if the hearing proves that a violation more likely than not happened, then the judge would apply a remedy. And again, these are kind of the basics. There are a lot more materials that we will link in the chat and send out in follow-up emails to folks after, and that folks can currently access, who are currently incarcerated either in California jails or prisons through the Adobo tablet, through the Adobo app on their tablets, free of charge, and at the Ella Baker Center and OSPD and some of our other allied organizations also send out to folks that contain a lot of information that can help people prepare and be as ready as possible to file these RJA claims. And with that, that's kind of a wrap up of what some of the basics are around the RJA, and we'll love to pass it back to Fatima.
Right on. Thank you so much, Morgan, for that overview. Really good details, really good information. So that was a bit of an overview, right? And now we're going to talk about AB 1071 and SB 734 a little bit more in detail, less of an overview and giving folks a more detail that they can sink their teeth into. We have two really great speakers who's going to be talking to us about AB 1071 and SB 734. We have Belle and Brooke. Both are amazing attorneys who are going to be talking to us about these two bills.
Hi everyone, I'm Belle, and I'm really excited to talk to you a little bit about how we were able to get AB 1071 through the legislature and thanks to the incredible work that Assemblymember Kalra and his office did in sponsoring the bill, and of course all the great community organizations that are on this call co-sponsoring AB 1071 as well. And so I guess just quickly how a bill goes through the legislature. It's introduced by somebody, so an assembly member or a senator, and Assemblymember Kalra was our author, and it has to go talk to a lot of different people who care about this issue. So this bill specifically went through lots of reiterations of being drafted by different criminal defense attorneys and public defenders from all around the state. We had different community organizations go and talk to different legislatures about the bill, as well as talking to the committee staff. And this also meant that we had to talk to the legislatures officially in public about what this bill was and why they should vote or not vote for it. So just the bill itself first went to a committee. The committee has to look at it and decide whether or not this is something they want to support. And then the assembly, which is the lower house of the legislature, then voted on it. And then it has to get passed over to the Senate Public Safety Committee because this is a public safety issue. The committee voted on it, went to then an appropriations because there were some, the legislature just flagged that there were some fiscal issues with the bill. And then it went to Senate floor. After the Senate voted on it, then the governor, it was before the governor for him to sign if he wanted to sign it. So it was a very long process. This is the first time I've ever worked on a bill. I've ever worked on a bill, which means that I was definitely in suspense the whole time, every single time there was a vote. So that's kind of how a bill gets from the beginning to the end, and just wanted to highlight the incredible work the community showed up in supporting the bill. Like I said, we met with committee staff and other legal stakeholders to talk about the bill. We co-sponsors like everyone on this call, all of the panelists on this call met with different legislative staff and legislatures, both on Zoom and in their offices, to explain why this bill was so important. Like I said, we had to go before different committees. Somebody from Silicon Valley Debug explained, the real life implications about why AB 1071 would protect due process and carry out the vision that the Racial Justice Act had both in 2020 as well as 2022. And of course, we had a press conference in August, and you can see in the photos here all the people who came out to support AB 1071, as well as our Dream Alliance Lobby Day, where more than 25 people from the AB 1071 co-sponsor group went and met with different legislators and their staff about why AB 1071 and the other bills that the Dream Alliance supported was so important and needed to be passed. And then lastly, of course, I want to thank the incredible comms team. I think folks from IJ and Smart Justice and Ella Baker Center and other organizations and CCWP all put their heads together to create the beautiful visuals that you're seeing both on this slideshow as well as on social media. And without their support, we wouldn't have been able to get our message across about how important AB 1071 was. I'm going to turn it over to Brooke to talk about both AB 1071, which is the legislation that we co-sponsored, as well as SB 734, which is a Senate bill that also addresses the RJA.
Thanks, Belle, and welcome everyone. I'm really glad to have you here. My name is Brooke McCarthy. I'm with the Office of the State Public Defender. Specifically, I'm with our Indigent Defense Improvement Division. And I'm just going to walk you through some of the changes that were made in light of the legislation. So first, Fatima, can you or someone else also just drop the link to the handout in the chat when you have a chance? There's going to be just a kind of what we call a quick reference guide for everyone that gives a basic idea of the changes that AB 1071 made. And so just want to have that available for folks. But to start it off, I would just really encourage everyone to read the legislative findings of AB 1071. They are incredibly impactful for, one, what they say, but also in the courtrooms. It is rare for the legislature to agree on these types of legislative findings, and so they do carry quite a bit of weight actually in the courtrooms, and we are already starting to see some of their impact as well. We'll talk about, but I would really encourage everyone to read them and really see what the legislature is affirming that it's trying to do. Next slide. I'm going to highlight just a couple of the kind of big changes that happened. There are a lot of, excuse me, little tweaks that I don't think are as interesting to the broader community. But one of the first things is changes for remedies. The changes in the remedies section are intended to address case law that had been created saying that remedies were discretionary, particularly in pretrial cases. And so the changes you see here of the court, instead of it saying the court may, it says the court shall impose any of the following remedies, was hoping to change that case law. And then also the addition of D at the very bottom that you see there, any other remedy not prohibited by another law, was intended to try and give courts more discretion to impose a broader range of remedies when maybe the violations give the court pause when it comes to granting like an entire new trial, etc. So that's one change. Next. The next portion is around post-conviction wins. So as you will see on the bill, and is that a lot of changes were made to the post-conviction section. And a lot of this was just, it used to be one very clunky paragraph. It's now separated out into subdivisions. But the big clarifications are about making sure that all of the definitions and procedures that pretrial individuals have for AB 1071 are applicable to post-conviction individuals. And that link that Michelle has just dropped in the chat it also goes over all of these changes, not just the findings, etc. So would encourage people to click on that. The other clarifications that 1071 made is that individuals are allowed to file for discovery before filing a petition. I know this was a really big issue for folks who are inside. You're in a catch-22 if you need more information to get counsel, but they don't let you get the information. So now, hopefully, as of January 1st, that will be fixed. The other thing is reinforcing the standard for appointment of counsel. This language was slightly changed, actually. So now individuals are supposed to receive counsel upon pleading what we refer to as a plausible allegation of a violation. This means as of January 1st, for anyone who filed either for discovery or for counsel before and was denied, they will have the right to refile. I will say, though, I don't think there are many of these opportunities in the future where there will be enough changes in the law to allow you to file another petition. So I really caution folks to, like Morgan was saying, take your time, think this through. Do know that my office, the State Public Defender, is going to be releasing new resources in early 2026, including a pro per packet for individuals to walk through. Your loved ones very well may want to wait for those resources instead of risking filing and then being barred from filing again in the future. The last big win for post-conviction is around the evidentiary hearing. You now receive an evidentiary hearing after making just a prima facie showing. So it's somewhat legal. It used to be that you needed to make a prima facie showing of entitlement to relief, which was a higher bar. So this goes back to the RJA's lower standard for prima facie showing. And again, this language is a little bit more specific in the handout. If you want some more information on that. And you can also feel free to ask me questions in the chat as we go. Next slide. And then wanted to give some context on SB 734. One thing I would remind everybody of is that this is just applicable to attorneys. Your loved ones don't need to worry about giving copies, etc. And so this is just there was a lot of discussion around law enforcement individuals. And originally, Javier's bill said that they were allowed to file what's called an amicus brief, which would allow them basically to chime in on the case. That is not what defenders obviously wanted to have happen. And so SB 734 says they can be notified of a filing, and that includes their information, right? That their behavior or their words are being used. That can't be used against them in their disciplinary proceedings, which are a separate portion. And then again, the attorneys are the ones who need to notify them. So your loved ones should not be filing those copies on their own. They should wait till they have an attorney, and their attorney can handle it. And I think, Belle, it's back to you.
Awesome. Thanks, Brooke. And I really appreciate that comprehensive update on the different ways that AB 1071 has changed or has improved the RJA and really tried to cement the things that we were trying to accomplish with the original RJA as well as RJA for all. And with any new law, attorneys are now working really hard to make sure that not only we educate ourselves about what the changes in the law are, but we're also educating the court and often the prosecutor about what these changes are and how it reinforces the low standards that exist for post-conviction cases, as well as the new remedies that have been stated in pretrial cases. And so a couple of things that um, criminal defense attorneys and including public defenders have been doing to make sure that we're educating ourselves as well as the courts about those changes have been one, having our own webinars and creating training sheets to keep ourselves updated with AB 1071 and how that changes the RJA. For example, Brooke gave an incredible educational webinar a couple weeks ago about how AB 1071 changes the RJA so that folks who are doing RJA work and really all criminal defense attorneys who are looking out for RJA violations in their cases know how to move forward if they see an RJA violation. We are also like I said, making sure that the trial courts and the appellate courts know what the changes are. So, for example, in a lot of cases that are currently being litigated or being heard by the appellate courts, attorneys are encouraged to write a letter to let the court know that the issues that they're arguing before the court, that the court is considering right now, may be different on January 1st when AB 1071 is enacted. And so a lot of attorneys are writing letters to the court to let them know, hey, like this is, there's a new change in law. This is how this is going to affect my client, just to keep you updated. This is the same for trial courts. So folks who are currently fighting RJA cases in the court or have an RJA issue in their ongoing case, attorneys are letting the judges know, the defense attorneys are letting the judges know that, we may not be able to decide. You may not be able to decide this RJA issue until after January 1st. And even if you were to decide it today, in a couple of weeks, the law is different. And so you need to take into consideration what AB 1071 and how it clarifies what the RJA says. And some attorneys are doing this beautifully. Many attorneys are doing this beautifully. Brooke pointed out to the legislative findings that were drafted for and AB 1071 to reinforce some of the things that we here already know, the role that racism plays that plays in the criminal legal system, how it creates harm, right, to the integrity of the criminal legal system. It reminds the court and the public of specific cases but even Supreme Court justices acknowledge that if folks aren't able to get data or discovery to support their RJA claim, then they're never going to be able to file an RJA petition. And it's kind of a never-ending cycle that if we don't, if the standard isn't enforced at the appropriate level, then folks will never be able to address their RJA claims. So lawyers are reminding the court that, the legislature has found certain things to be true, that they believe that this is like what their policy intention is. And by reminding the judges, like Brooke said, those legislative findings are actually quite powerful with the judges who are currently hearing the cases. And so weaving those arguments in their motions now to show judges that, that this is why this is important. This is why their clients' RJA claims should be heard in this way, have been making an impact in the court. And we found that the appellate courts are listening. Not only are appellate courts asking lawyers if they haven't already submitted a letter saying that AB 1071 is passed, they're asking the lawyers to brief the issue, right? To explain to the court, does AB 1071 apply? And if it does, how does it apply? How does it maybe change their arguments? Or is it something that the court even needs to consider anymore now that AB 1071 has changed something? So, for example, in the Montgomery case, where somebody who's currently incarcerated had argued to the court that they should get data or discovery to support their RJA claim, and the first court that Mr. Montgomery went to said, I don't even have the power to hear this request of yours. That case had gone on to had come up to the Supreme Court, and now they're talking about, does AB 1071 change that? For Mr. Montgomery, because AB 1071 now explicitly says that someone like Mr. Montgomery can go to the court, and the court does have the power to hear his request to receive discovery. In another case where the Court of Appeal has taken notice of AB 1071, have noticed it, is an incredible case out of Los Angeles County, the Vernado v. Superior Court, which is from the 2nd District. In that case, it's not published, which means that attorneys can't cite it, but the judges there do a really great job, looking at AB 1071 and deciding in that case to get past prima facie, which is that first step, that showing statistics is enough to make a prima facie showing, which means that just having statistics and not needing factual comparisons is enough to get that evidentiary hearing, which is that second step for RJA. So it's been really great, even before AB 1071 has been enacted, which again is in a couple of weeks, that the Court of Appeal and the Supreme Court is already listening and following along with what the law will be in January 1st. So we're really excited, and attorneys will keep working incredibly hard to litigate these RJA cases, taking into consideration how AB 1071 states that standards are low, and we're able to also encourage folks who are filing their RJA petitions to get appointment of counsel, to make sure that they're getting attorneys and moving their cases forward. So that's my update. I'm going to turn it over to Cecilia from Silicon Valley Debug to talk about some of the things that our great community organizations, especially Silicon Valley Debug, has been doing around AB 1071.
Good afternoon, everyone. My name is Cecilia, and I'm an organizer with a local org in the Bay Area called Silicon Valley Debug. We also support a number of other organizations across the state of California. And one of the things that we've been doing is kind of communicating and cross-pollinating in the type of families that are coming to the meetings and how we could share the lessons and learn from other organizations with the families that we're working locally. Because remember, the RJA is very localized. It depends, all the data information that's being talked about has to be specific to the jurisdiction that your loved one was convicted or is being charged in. So I do want to take it back a little bit because I don't see who's in the webinar because I only see our lovely panelists. But for any of those families that are here, I understand there's a lot of like technicalities and legal terms being thrown out, which is all super important to actually get cases into the court. But just remember, if you have a gut feeling that something wrong happened in your case, or that there were comments made about your loved one in the case, and you just have that gut feeling saying that's messed up, maybe we should explore the RJA, then that is what this bill has been and is intended for, to explore those gut feelings that say something is wrong and we should rectify that. So whether you have a loved one in local custody or a loved one who's already served years behind in prison cells, there's a lot of things that you could do to support them. And it's too much to go through in this short webinar, but if you could go into our participatory defense.org website, you could find a local organization that's close to you to support you, or you could also contact me directly. Some of the things that we've been seeing, kind of what the purpose of the webinar is, some of the things that we have been seeing in the past 5 years is that the RJA has been a very slow moving vehicle. And that's understandable because you are pushing against a system that is very comfortable the way it is right now, and they don't want to. They don't want any pushback. DAs don't want to give up data, which is why we had to do AB 1071. As you heard from our lovely attorneys previously, even the Supreme Court or the appellate courts are having a hard time kind of dissecting or trying to understand how to implement the RJA. So we're all in, we're building this plane as we're flying it. So this is, we're all learning. This is why there's been different reiterations of the RJA. So the purpose of the network that we've created is to really do that, to support one another and throw the noodles against the wall and see what sticks. Because that's what we do as community organizers. Some of the things that we're seeing, one, yes, is the pushback, but two is also this is an opportunity for you to really engage with your attorney, either be it whether you're in pretrial stage or your loved one is in the post-conviction stage. It's an opportunity to engage with the attorney, and if you're not acquainted with the criminal court process, this is the time to learn. And like I said, contact your local public defender or contact your local participatory defense organization, and we will walk with you this path. In another thing that we've learned through the RJA has been that this is really an organizing tool as well, because the more engaged you get with your loved one's case, you get to see all the injustices that the system has done. So as you're engaging with the system, you're able to now target different areas of the criminal court process to hopefully bring your loved one home. Another kind of angle with the RJA is that this could be one of the avenues to bring your loved one home. So luckily, California has passed a number of resentencing reforms in the past couple of years. And what we've seen is that the RJA has been a motivator to get your loved one out through other avenues. Because speaking frankly, the DAs don't want to put in the work to pull out years, record old cases, boxes in Contra Costa. They claimed it would take them 10 years to pull out records of loved ones, 5 to 10 years. So they don't want to do that work. It is very costly for the court. So then the system is motivated to funnel your loved one into a more expedited route. So we've seen the RJA being used kind of as a leverage tool. So use that wisely with your loved one and your defense attorney. So what that means is if your loved one's been incarcerated, they might have an opportunity at a AB 600 petition or recall for their sentence. They might have an avenue to be prosecuted, to go through the prosecutor initiated resentencing petition, or they might have, which might advance them in different forms to get earlier parole release. So it's very important to, as Morgan said in the beginning, really take your time and explore how to utilize this new avenue for relief. Because although you might not get to an actual RJ hearing, it might bring you closer home through other avenues. Because that's what we've seen in, at least in our county, in Santa Clara County, when the public defender threatens the DA, I'm going to file an RJA. They're like, okay, I'm going to let them go out this other way. So that's kind of, a strategy you want to really consider with your defense attorney as well. And if you have pushback from defense attorneys, because we've definitely had pushbacks with defense attorneys, contact your supervisors. You know, the listserv that Belle mentioned, or the meetings that Belle mentioned, this is all intended to support your loved ones. So there should be no reason why you're getting pushback from your defense attorneys, if we're all going for the same goal. So, and also contact your participatory defense hub. That's another way to kind of get that kind of support. I think we are running a little bit early. But if there's any other questions regarding like how participatory defense can support your loved one, let me know. I will put down my email. It's Cecilia at Silicon Valley Debug. We have a website dedicated just to the what we're learning from the RJA, because when we learn, you all learn. So we try to share all of these this information collectively so that we could support one another and hopefully bring your loved one home as well. And that's through the rjaaction.org website. And it's not intended to give any type of legal advisement or anything. These are just learnings from the community of how we've seen this law really play in the courts and with the loved ones, and to give examples of the type of cases that we're seeing, not just in the Bay Area, but across the state. And with that, I will pass it on to Fatima to introduce the next speaker.
Right on. Thank you so much, Cecilia, for all the work you do and everything you just shared. I see lots of questions being entered in the chat. Please continue to do so as we go from speaker to speaker. We actually have some recordings from folks inside that we're going to share with people. I believe we're going to be hearing from someone named Kevin Cooper, as well as someone named Caramel. So we're going to listen to that now.
This fight for the this fight for the Racial Justice Act, since its inception in 2020, has meant that for the first time, if ever, people in the government and in the state government acknowledge that racism actually exists. Knowing it exists is one thing, but acknowledging that it exists is something completely different. And because it's been acknowledged, then maybe somewhere down the line, maybe not in my lifetime, we can end it, because racism is in the DNA of this country. There is nothing that goes on in this country where race is not involved. This is why the Trump administration is trying so hard to end that DEI, diversity, equality, and inclusion. They want an all-white world like it was when he said America was great. So having a Racial Justice Act in this state means a lot to me and people like me who have racism embedded in their case, because racism is embedded in the criminal justice system, especially when it comes to the death penalty, especially these executions. Lynching back then is lynching now. It's just that back then it was public, and now it's more or less private, the way it's constructed. Hopefully set some people free when they can really prove that racism, real live Americanized racism, is part of their case. Finally, I'd like to say this on this subject. Many a black man and black woman have been sentenced to decades of life or even a death penalty in prison because they've been sentenced in front of an all-white jury with an all-white judge and an all-white prosecutor and given a white public defender. Now let's reverse the roles, and let's say a white person was given a black public defender, there's a black district attorney, there's an all-black jury and a black judge. Would they think they was getting justice? But yet they want us to think that we get justice, or they want the world to think that we get justice, black people, when we're in front of an all-white jury, an all-white judge, and the white district attorney and all that stuff. So now, get real. We got to end this stuff, and this is the start of it. What I'm looking forward to is meeting a lot of people who help fight for this thing and help get it passed. You know, I don't mean the politicians necessarily. I mean the grassroots people, which I am one of. I am from the grassroots. And I look forward to meeting them and thanking them in person because their effort, you know, their fight, their endurance, their refusing to take no for an answer is why we got the Racial Justice Act passed and then passed again and then passed again. Because remember, when it was first passed, it wasn't retroactive. It didn't affect people on death row. Then they got it, you know, to do that. And now they got this new one, AB 1071. So, yeah, I look forward to that, meeting people, thanking them, and hoping, like I said, that this makes a difference. Because there's a lot, you know, America and these politicians pride themselves in saying that this is a country of laws. Well, a whole lot of them laws ain't no damn good. And even when you use them, maybe find another law to deny it. So hopefully this will happen with the Racial Justice Act. It is now a law. And hopefully it will be respected as such and dealt with as such. And they will not be able to find another law to deny us the truth that we got coming under the Racial Justice Act. So this is a slippery slope, but I believe that all of us may not get justice out of it, and you know some of us will, and some of us is better than none of us.
Hello, everyone. My name is Carmel Murphy. I'm currently incarcerated at CCWF. I'm currently serving an LWAC sentence, and I was asked to answer a couple of questions regarding the RJA. And so how that's working out for the community here. And so I just feel like the RJA was a really good win. It was difficult. And I also feel like today that hopefully it can prevent the judicial system from demoralizing people. I also feel like it widens the scope for people to file petitions due to the RJA, and there was like a lot of barriers, and I know that there's also like limited resources for people to obtain the needed data. I know sometimes the counties talk about lack of funding to implement, which is something called the 2022 Justice Data Accountability and Transparency Act, which that would help people to better obtain the data that they need, because usually we find complicated here is that out there, like, you know, there's AI, there's so many resources, and you guys come out to like stamp the law and different things like that to obtain the statistical things that we need basically to do for the petition, so the petition is not denied. So I think that is a barrier for the communities that are incarcerated. But just a recent win with the AB 1071 kind of opens it up and makes it less difficult for the courts to deny a RJA claim. So I feel like it gives more help and assistance in obtaining the support needed, as well as RJA claims needs more staff for like the personal discovery transcript, from like preliminary hearing and trial of those things, because those are things that you can use to like prove like different things that were said about you during the trial, or even just in each county the disparity with the sentencing for, you know, African Americans, people of color. There's such a difference in that, especially with the youth being African American and being given like sentences and LWAC sentences there's just not a lot of opportunity for these kinds of things. So I feel like RJA opens up a lot more doors and brings a lot more hope for the injustice that has been done and the disparities in sentencing. I also feel like RJA will give these counties an opportunity to be able to right their wrongs. So we may find some complications with that, but I feel like it will try to lessen people's sentence and alleviate them an opportunity that they previously didn't have.
All right. We've just shared a lot of information with folks. We've had a lot of speakers talk. We are nearing the end, but I'm going to invite everybody to just take a self-regulated, at your own pace, deep breath whenever you're ready. All right. We are coming towards the end. We do have some resources that we want to share with you, as well as some action items, things you can do to get involved. I believe Morgan is going to talk to us and give us some more information about this resource guide that we have here.
Absolutely. And if the slides could be shared so that folks could see the resources. Thank you. There are a few resources that we will share out after the fact, but really want to uplift and thank all of the organizations here today that have supported this effort for the RJA. We'll have a EBC's calls to action document for ways to plug into this work and connect, and want to also uplift AFSC and some of the other organizations as well that have contributed to this work. Those are all linked there. There are also resources that will be shared out again in an email, including the slides from this presentation, as well as a recording of this presentation to everyone who did register today. Those resources will all be linked and contain some really vital information, and I think also get to some of the questions that folks have been asking too, especially I think, to kind of lead us into Q&A and some of the questions that have been asked. Someone asked how to gather the type of information that is needed to bring RJA claims. And we have listed some really great data resources that currently exist, but there are also tons of other ways that folks can get resources and information. And again, some of those resources like the RJA guide and the frequently asked questions and Debug's RJ action page are all really great starts to try to get that information. But some other ways that folks can support their loved ones or support themselves is to begin by going through trial transcripts, criminal records, someone's abstract of judgment from their sentencing. Also finding news stories about key people or agencies involved in the individual's case that could help support those claims of bias and discrimination. Any reports or statistics, some of those data resources are great for that, and even one-pagers around specific types of convictions or sentences in a particular county are also really great to look at. Folks who are currently incarcerated also have access to data and information from CDCR. They can consult their facilities librarian, and that also goes for other folks too. You can consult librarians at your local library for research purposes. There are academic journals, newspaper articles, lots of information that contain vital resources that can be used to help support RJA claims. And for those are just kind of the starting points, and I know it's a lot to kind of look through and think about and try to collate together, but Again, we will always suggest reaching out to your county's public defender's office or participatory defense hub to get started. And like Brooke mentioned earlier, the Office of the State Public Defender will also be having some other resources come out soon that will support this work even more. I don't see any new questions in the chat, so I also wanted to uplift two other questions that came up around attorneys. Again, we know that the law is new and there aren't as many resources as folks would like or need to be able to bring these RJA claims right now. But for anyone who's looking for an attorney, again, we suggest trying to reach out to the public defender's office first, or some of the more reputable resources. Always want to caution folks and make sure that they're doing their due diligence before hiring a private attorney, because we always want to make sure that our communities are protected, especially our most vulnerable communities, those who are directly impacted and currently incarcerated, from anyone who may be trying to take advantage of their situation. So again, starting by reaching out to some of those agencies, to the Office of the State Public Defender. If you are hiring a private attorney, checking the California Bar website to make sure that they don't have any disciplinary action against them are all good places to start. And if you do have an attorney currently appointed for your loved one or for yourself, and they have any questions about process or about the RJA, great to reach out to the Office of the State Public Defender, to Brooke or Belle directly, have that attorney reach out to them so that they could get some of the support that they may need to bring those claims. And again, we'll be following up from this webinar with all of the resources linked in an email, as well as the recordings and some of those answers to the questions that you all have asked today.
All right, then that concludes our event for this evening. Happy Friday, folks. All of your questions and engagement really does contribute to helping move the work forward. I know there's a lot of things happening in our world even today, despite this big win. So just keep in mind as we release you back out into the world, the work continues beyond today, but let today be proof that when community stands together, justice will move forward.